Good evening, ladies and gentlemen. I, on behalf of Team Legal Expatriate and GD Goenka University Gurugram, welcome you all to the sixth day of 7 days online certificate course on drafting of different writ petitions, for which we are honored to have with us Honorable Dr. Swati Jindal Garg, who is an advocate on record practicing in Supreme Court of India, Delhi High Court, and all district courts and tribunals in Delhi. She has done her doctorate in criminal law and is the legal member of the internal committee of various private as well as government organizations. The speaker is also an impaneled advocate in various government institutions, including the Ministry of Environment, Forest and Climate Change, before the National Green Tribunal. She is also empaneled with Union of India for Supreme Court of India and a visiting lecturer in Law Center 1, Law Faculty, Delhi University. Dr. Garg is a trained mediator empaneled with the Supreme Court and the National Consumer Disputes Redressal Commission. She has been writing on various legal issues in reputed journals and legal magazines and has also authored books on legal issues impacting women as a working on women-related issues is her keen area of interest. Confidence building and leadership development of women is close to her heart, and she is a firm believer of the fact that holistic development happens. Women coach women and take each other forward. We are honored to have with us such an eminent persona for our today's session. Before handing over the session to ma'am, I would request all the participants to switch off their audio and video so that it would not create any hindrance in the ongoing session. Over to you, ma'am.
Thank you so much for such a wonderful introduction. The class today, the lecture today is on a drafting of writs on a PIL. There are certain specific kind of writs that have been given to us. One of them being how to challenge the order of a caste scrutiny committee. The other being how to draft a PIL before the Supreme Court or the High Court for that matter. Similarly, there is another topic about the filing of an election petition, how to challenge the outcome of an election. So all three are quite interesting topics, especially PILs. Today, we all know quite a hot topic today because of so many people filing various kinds of PIL, including various advocates and also public-spirited persons in general. I'm good to go. Whenever you guys say, we'll start. And I would like to start with a little bit of introduction on all three topics before we actually move on to the actual drafting, so that you guys have a basic idea of what we are talking about before you actually learn how to draft it. So let me know whenever you're ready. We can begin.
Ma'am, you can start.
All right. So the first topic that we have today is a writ petition. Now, as you all can see, I hope the screen is visible to all of you.
Yes, ma'am.
All right. So writ is a formal written order by the court to an individual. It can be to an organization or the state as well, wherein they command constitutional remedies against the violation of people's fundamental rights. So primarily, if you approach the court in a writ, you have to show that any or all of your fundamental rights have been violated. How do you approach the court? You approach the court under Articles 32, as far as the Supreme Court is concerned, and Article 226 of our Indian Constitution, in order to enable the Indian citizens to move to the High Courts or the Supreme Court in case of violation of their fundamental rights. Now, the article also empowers the Supreme Court to issue writs for enforcement of the fundamental rights of the people. Now, state high courts can also issue writs under Article 226 or 227 of the Indian Constitution. Now, moving ahead, when we talk about writs, it is imperative for us to know what type of writs are there before us. How can we take benefit of these writs? Now, there are primarily 5 types of writs: habeas corpus, the writ of mandamus, the writ of prohibition, the writ of certiorari, and the writ of quo warranto. I've given the relevant Hindi names. Most of you might not even have heard of them. Habeas corpus is called Bandi Pratyakshikaran in Hindi. The writ of mandamus, also known as Parmadesh writ. The writ of prohibition, also called the Pratishedh writ. Writ of certiorari, also called as the Utpreshan Lek. And the writ of quo warranto, called as Adhikar Pisha. See, before we move ahead, you have to understand that whether it is an election petition, whether it is a PIL or a writ challenging the order of a caste scrutiny committee, there is a basic format that is taken care of. Of course, as far as the drafting of a PIL is concerned, there is no formal draft. There is no formal style or not a particular style that you have to follow, because you must have heard of cases where a letter is written to the CJI, the Honorable CJI, and the Supreme Court would take cognizance of the letter and convert it into a public interest litigation. Various cases have happened. So, considering that a letter can be converted into a PIL, it is quite safe to say that there is no correct or no formal format for a PIL. However, there are certain things that every PIL should include. So we would be taking that up during the course of the lecture. As far as the format of a writ petition is concerned, please understand that it has to have the synopsis and the list of dates. Then from the next page onwards, it has to have a certain format. For example, if you're filing a writ in the Supreme Court of India, you have to write at the top in the Supreme Court of India, under that original jurisdiction, under that civil writ petition number so-and-so of the year. You have to mention the year. For example, if you're filing it in this year, it'll be civil writ petition number so-and-so of the year 2024. Then you have to mention the name of the matter. In the matter of dash versus dash. So petitioner would be, for example, Mr. X, and then it will be versus the respondents. Now, because this is a writ, one of the respondents would have to be a state party. Then you write under bold, running caps, petition under article so-and-so of the Constitution of India for the issuance of a writ in the nature of whatever. Suppose you're asking for a writ of mandamus, for example, under article dash of the Constitution of India. Under that, now you begin with the line that says to the Honorable the Chief Justice of India and his Lordship's companion justices of the Supreme Court of India, the humble petition of the petitioner above named states as under, or most respectfully showeth. Then you go on to write in the para number 1, facts of the case. Whatever your case is about, you would write the facts. Now, each consecutive para that talks about the facts of the case is going to be numbered as 1.1, 1.2, 1.3, so on and so forth. Now, once the enumeration of the facts is complete, then thereafter you move on to the questions of law. What is it? What question of law are you putting forth before the court? So every subsequent question of law would be 2.1, 2.2, 2.3, so on and so forth. Then the third para onwards would be the grounds on which you come before the court. Again, now, if there are multiple grounds, they would be numbered as 3.1, 3.2, so on and so forth. In the fourth para, we have the averment that states that the present petitioner has not filed any other petition in any High Court or the Supreme Court of India on the subject matter of the present petition. So now this para is of utmost importance. If this para is not there, your petition would be under defect. It would not be listed. Why do you think that this para is there? Anyone would like to chip in? Any idea? Why do we have this para, this averment that says that the present petitioner has not filed any other petition in any High Court or the Supreme Court of India on the subject matter of the present petition? Because you cannot have multiple cases going on the same question of law. Yes. All right. So then we have, at the end, we have the prayer. In the above premises, it is prayed. Premises, it is prayed that this honorable court may be pleased to. You go on and you write down what it is that you pray for. A, B, C, D, small Roman 1, 2, 3. And any prayer that you write has to be at the end accompanied by a sort of an all-inclusive prayer that talks about to pass such other orders and further orders as may be deemed necessary on the facts and in the circumstances of the present case. So this is one prayer that you write so that in case something is missed out inadvertently, then it can always be covered under this particular prayer. All right, so for which act of kindness the petitioner shall, as in duty bound, ever pray. And then you write at the end, filed by and drawn by. Why is it that these are two different things? One says drawn by and the other says filed by. Why? Because this is a petition before the Honorable Supreme Court. And in the Supreme Court, the filing can only be done through an AOR, right? So in case the AOR also happens to be the person who has also drafted the petition, in that scenario, the person who's drawing the petition and the person who's filing the petition will be one and the same. You also mentioned the date on which the petition is filed. That is why we have at the end of the petition, that thing that says that filed on. So there you have to write the date. Now, the writ petition should also be accompanied by the affidavit of the petitioner. Now, whoever is filing the petition, he has to also file an affidavit, duly sworn and attested. Then annexure as referred to in the writ petition. Whatever, when you write down the facts, when you write down the synopsis, the list of dates, you are relying on certain annexures. So all those annexures have to be annexed in the writ petition. Then there will always be a court fee of ₹500 per petitioner. If it happens to be a criminal matter, in that case, there is no court fee. We have to have one index. I have also enclosed a specimen along with this particular presentation. We'll come to it subsequently. Your petition will have to have a cover page. Any application that you file along with your petition, you have to you pay a court fee of ₹120 per application. Then there will be a memo of appearance, which is so to say that, okay, who all are appearing in this particular case. So that memo, almost it's like a wakalatnama. Then an application seeking permission to appear and argue in person. Now, if you are a person who wants to argue your case in person, then you have to file an application in order to seek permission for the same. And in case of the petition wherein it is filed by a petitioner in person, a court fee of ₹120 needs to be attached. Now, see, we were talking about the petition having an index. Index is something that looks like this. Please look at the left-hand side of the screen, titled index. Serial number 1, we have the synopsis and the list of dates, which is what the petition would start with. Thereafter, we have at serial number 2, the writ petition along with the affidavit of the petitioner in support. Followed by at serial number 3, all the annexures that you seek to rely on. And right at the end, you'll have the application at serial number 4. So any application, maybe it's a stay, it is some sort of an interim relief that you want to rely on. Then the next page, which is basically the right-hand side of the screen that you see, we have the cover page. This is what your petition's cover page looks like if it is filed in the Supreme Court of India. It starts with in the Supreme Court of India, then we have original jurisdiction. Below that, we have the civil writ petition number so-and-so of 2024. We have the name of the case, dash versus dash, which is basically the name of the petitioner versus the name of the respondents. Then you write the paper book, then you cite for index, kindly see inside, filed by. This, of course, has the name of the advocate on record. Below that, you write advocate for the petitioner or petitioner in person, whatever the case may be. And then on the bottom left side, you would write the date on which you are filing the petition. Now, I told you primarily a PIL or a order challenging the caste scrutiny committee or an election petition, they're all formats, similar sort of formats for writ petitions only. Now, the first sort of writ petition that we will be talking about today is a public interest litigation. All right, let's proceed. Now, what exactly is a PIL? Well, a PIL is not defined as such in any statute or in any act. If you look it up, you will not find an article that particularly talks about a public interest litigation. It has been interpreted by the judges to consider the intent of the public at large. What is it that, the public actually, what will be the good for the public? Now, according to the Supreme Court, in the case Janata Dal versus H.S. Chaudhary, it is a 1993 judgment. A PIL or a public interest litigation means a legal action started in a court of law for the enforcement of public or the general interest, where the public or a particular class of the public have some interest, including any sort of pecuniary interest that affects their legal rights or liabilities. So any sort of interest that affects their legal right can be, you can seek protection under a PIL for any sort of interest. Now, the next is, if you look at what the historical background of a PIL is now. If you see the concept of PIL and its origins, you have to go back to 1960s, and it has its origin in the United States of America. In India, however, Justice Bhagwati has been called the father of public interest litigation because of his contribution to PIL jurisprudence. Now, Justice Bhagwati was the CJI from July 12th, 1985 to December 20th, 1986 now. As far as the females are concerned, Pushpa Kapila Hingorani was a trailblazing Indian lawyer who is widely recognized as the mother of public interest litigation in India. Just have a look now. Over 9 lakh PILs have been filed in the Supreme Court between the year 1985 to 2020. So if you see the number of PILs received by the Supreme Court starting from 1986, if you see the chart, it goes up and down, and it shoots up somewhere in 2019, right at the top where you see the 70,000 mark. And then it falls down a little bit in the year 2020, maybe because of the imposition of the COVID, sort of the cases were not being filed, and then there was a reduction in litigation at that time. So that is why that drop you can see. Otherwise, the number of PILs filing has increased drastically over a period of years, if you can see, starting from 86 to 2020. Now, who is it that can file a PIL? So any citizen, any public-spirited citizen can file a public case by filing a petition under Article 32 of the Indian Constitution in the Supreme Court, or under Article 226 of the Indian Constitution in the High Court. Now, PIL serves several important functions in a democratic society. Primarily, it is aimed at promoting justice, accountability, and the welfare of the broader public. Now, like I said, right at the beginning, courts also, it's not necessary that you have to go ahead and file a PIL. Courts also have the power and the authority to take suo moto. That means on their own, cognizance of matters involving public interest. Now, this means that if the court becomes aware of a situation that requires its intervention, it can initiate proceedings even without a formal petition. If you look at the recent examples, the latest example is that of COVID-19, where the court took suo moto cognizance of the spread of COVID-19 during the Kanwad Yatra, and then the delay in the release of convicts despite the grant of bail. Then we have the Delhi air pollution case, the Lakhimpur Kheri case, and also the cognizance of the death of the additional session judge Dhanbad. All these cases, the court stepped in, took suo moto cognizance, and it got converted into a PIL. Then if you look at the history of PIL in India, Mumbai Kamgar Sabha versus Abdul Tyagi. Now, there is a typographical error here. It is Abdul Tyagi, 1976 case. In this case, Justice Krishna Iyer argued that PIL had an important role to play in ensuring that the legal system served the interest of the poor and the oppressed. He emphasized that PIL was not a substitute for traditional litigation, but rather to complement it. So it's not like filing of a PIL would, is something separate, or this would replace the entire legal system. This is something just to kind of make the legal system as a whole more strong. Then, of course, we have the Hussaina Khatun case. It was the first reported instance of PIL which brought attention to the inhuman conditions of prisoners and the under trial prisoners. And this case established the right to speedy justice as a basic fundamental right. Now, coming to how do we draft? Now, this is what the lecture today is all about. For this, I would rather take up an actual PIL that we have filed in the court. If you guys can see. Okay, there seems to be. Let me check. There seems to be some problem. This is not. To share the screen. Screen sharing has been paused. All right. I think, yes. Can you see it now? Oh, this is,
Yes, ma'am.
This is an actual PIL that has been filed by us. If you see, this is what it looks like. This is how it starts. These are certain formats that are available. And you have to just see, if you see right from the beginning, Form 28 with certificate, whether it has been attached. So these are certain requirements that you need to fulfill. And you have to write at the end, yes, no, not applicable, so on and so forth. This is the format that is available everywhere. This is a declaration that we have verified everything. Contents are in conformity with the rules. This is a declaration by the AOR. Now this is this is how it starts. Now, this particular matter is titled Mandona Rural Development Foundation through its director versus the Union of India. You see, in the Supreme Court of India, original writ jurisdiction, PIL litigation dash of 2023. Because it's a public interest litigation instead of writ jurisdiction, this is how you write it right at the beginning. This is the title page, paper book for index, please see inside with advocate for the petitioner. Now see, this is the index. This is the listing performer. See, this is the declaration that no similar matter is pending. Again, we come to the index. Mentions the cover page is there, the index is there, limitation report, whether the matter is out of limitation or not. Then we have starting with the synopsis. Now, this is where if you see the serial number 8, this is where the actual petition would start with the synopsis and relevant dates and events. Then this is the writ petition with the affidavit. This is the appendix, which basically includes what all articles we are relying upon. Then we have the first annexure, second one. P stands for petitioner. So petitioner 4, then annexure 5. Actually, this is where the see. Now, this particular synopsis and list of dates, you just give a short gist of what your matter is. If you see the numbering, starts with A, B, C, D at the beginning. Now, petitioner is filing the present civil writ petition. Now, even though this is a civil writ petition under Article 32, a special name of public interest litigation has been given to it because this has been filed not for any sort of personal, this is not a personal grievance that we have. We want this particular relief to be given to the entire public at large. All right, so you give us short synopsis of what is the main sort of contention in this case. For example, in this one, I'll read it out to you. Petitioner is filing the present civil writ petition under Article 32 of the Constitution, read with order 38 of the Supreme Court Rules 2013 to enforce fundamental rights, particularly the right to life and personal liberty, which is Article 21, right to equality, Article 15, Article 16, Article 19, guaranteed by the Constitution of India. Now, the main issues that we are contending that arise in this writ petition are non-compliance with the provisions of Clause 3 of Article 243D. Now, if you remember, 243D talks about the reservation of seats in the panchayats. And Clause 4 of the Article 243D talks about, which was actually added by the 73rd Amendment, it says, the Act provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to the SC and ST, not less than 1/3 of the total number of offices of chairpersons in the panchayat at each level shall be reserved for women. Now, what we contend in this particular PIL is, I would just make it short and clear for you to understand, is that even though the Constitution talks about the reservation of seats for women, and these women are actually sitting on these seats, yet they are suffering from the concept of sarpanch pati, where even though they are the sarpanch in name, the person who's actually working happens to be either her husband, her son, her nephew, any male relative of hers. So even though on paper we have the woman serving as a sarpanch, it is actually the sarpanch pati who takes the lead. And this is what we want. This issue is what we want to address. So we go on and we explain this concept in the form of a very short synopsis. Now, if you look at this sort of a table, these are the relevant dates and events. So we start right at the beginning in 1957, when the National Development Council constituted a committee headed by the Balwant Rai Mehta Committee to look into the working of the community development program. So we are starting right at the beginning, how the story started, coming to 1959, where Rajasthan was the first state to establish Panchayati Raj. Then we go on to November 1959, where Andhra Pradesh also the scheme was introduced. 1978, West Bengal. 85, Karnataka Panchayati Raj Act. 86, constitutionalizing of the Panchayati Raj started during this year with the LM Singhvi Committee. 88, then 89. Now, in 1989, the 64th Constitutional Amendment Bill is introduced in the Parliament. 90, we have the 74th Constitutional Amendment Bill. 92, both the houses passed the bill. 93, 73rd Amendment Act came into force. 94, all state governments passed conformity acts. 96, the provisions of the Panchayat Act was enacted. 2001, then we jump straight away from 96 to 2001, where the 83rd Constitutional Amendment Act amends Article 243M. Now see, this is how we are going. And then we are coming to the actual writ petition. If you see, it is titled Supreme Court of India, Civil Original Jurisdiction, writ petition number so-and-so of 2023 under Article 32 of the Constitution of India, public interest litigation. Now we write in the matter of, now this is the petitioner, you can see, and then versus the Union of India. Now this part now, if you see this bold caps, this part is very, very important, as this is what tells us what this public interest litigation is all about. Now, a PIL under Article 32 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, whereby the petitioner is praying for the constitution of a committee to examine the entire issue of making reservation for women Panchayat Raj institution effective and meaningful, and to issue appropriate writ order directions for issuing guidelines to prevent the wide-scale practice being followed on the ground whereby women sarpanches, gram pradhans are being represented by the male members of the family of such sarpanches in official meetings and also the running of the day-to-day affairs of the gram panchayat, panchayati raj institutions. Now, then we start with this formal address to the Honorable, the Chief Justice of India and his companion judges of the Honorable Supreme Court of India. The humble petition of the petitioner above named most respectfully showeth. Now, you give a little introduction of who the petitioner is. Here, it's a non-profit company registered under Section 8 of the Companies Act. You go on to say what all they have done. Why is it that they are public-spirited? What are they deriving any personal interest? In which case, this PIL will not be allowed. Now, you have to categorically state the petitioner has no personal interest or private oblique motive in filing the instated petition. Then go on to say what the problem is, what is the Panchayati Raj as an institution of self-governance, right? You give a little bit of gist. Now, then you talk about which article you're relying on when you file this petition, that through this petition under Article 32 of the Constitution, read with Order 38 of the Supreme Court rules, petitioner inter alia means, among other things, seeks issuance of writ of mandamus or any other appropriate writ, order or directions to the respondent for effective implementation of the clauses under Article 243 of the Constitution of India. So we are saying, even though this Article 243 is present in the Constitution of India, it is not being implemented properly. So what we ask through this PIL is the proper implementation of Article 243. We are also saying that the government of India, to empower women and ensure their participation in political process and decision making at grassroots level, has reserved 1/3 seats, but these seats are not being governed actually by the women, and it is their male counterparts, their relatives, who are making use of this power. Now, see, we are relying on certain annexures. The available data of the number of women chairpersons in the states from the Press Information Bureau is annexed as Annexure A1. So we are relying on this annexure. So we mark it as A1. Then we give a little bit of story as to how things are conspiring. And these are basically the facts. See, the remarks given by the Honorable Prime Minister have been annexed as A2. So the Honorable Prime Minister had given a call to end the practice of husbands of women sarpanches or sarpanchpati. So this is what we rely upon. Again, this certain literature that we are relying upon. These are all parts of the facts. That despite of the reservation, the effective political power and decision-making is wielded by husbands of elected women, called Sarpanchpati, Sarpanch Devars, Pradhanpati, etc. Percentage of women sarpanches in India, as per the article published in Hindustan Times newspaper, annexed as Annexure A4. Now, this is where, starting from para 10, this is where we identify the reasons behind Sarpanchpati practice, that women are not empowered, women are just heads in name, they don't have actual power. 86% of the women, even though they stood for Panchayat and Zilla Parishad elections, it was only because the seat was reserved and they are proxies. Despite being elected, the men of the family are the heads. See, all these are the grounds basically on which the fact that from the fear for their family customs and social ostracization, hundreds of women elected representatives do not assume office. 1/3 reservation, even though it gives legitimacy to the entry of women, but it has failed to create a political space for women. So we go ahead. These are all grounds that we enumerate. Right? So on and so forth. You see how we have incorporated various. Now, the Honorable Supreme Court, these are the grounds that we write. Why is it that we want this petition to be allowed? Democracy is part of a basic structure. Reservation for women was hard earned, and we can't just let it go wasted. This litigation is not adversarial, as in we are not fighting with anyone. We just want that public good should happen for everyone. This is something where benefit would accrue to all people. Now, this petitioner has not filed any writ petition before this honorable court or before any other court seeking the same and similar relief. So this is a declaration that we give, that we are not coming before the court after having filed multiple other petitions on the same topic. That the petitioner seeks directions of this honorable court as there is no alternative remedy except filing this present petition. Then we go on to enumerate the prayer. Constitute a committee of experts to examine the issue of women pradhans being represented by the male members of their family. Frame questions for them to be answered by the committee, taken into account the report submitted by this committee. Honorable court may be pleased to pass such other orders as may be considered appropriate for making the reservation for women meaningful, as promised by Part 9 of the Constitution of India and also Panchayat Raj Act passed by various state governments in India. And then finally, the most important of all, pass any other order or orders as may be considered appropriate. Then we come here, filed by so-and-so. Then we write the date right at the end. Now, this is the affidavit that is filed in support on behalf of the petitioner organization. This is the appendix. Now, this is what we are relying upon. This is the legal sort of section, article that is in contention here. You write it in the appendix. This is only for the Supreme Court cases. This is not required in the High Court. Right? We are relying upon 243E, 243F, 243G, 243H, 243I, J, K, 243L, so on and so forth. So these are the, then we have the various annexures. You see, this is how we title them: annexure A4, various annexures that we have included. In order to support your contentions. Quite a long petition, this one. Now, see, this is what court fee. And this is how the Wakalatnama looks like. All right. Let's go back to our main petition now. Right, I'll have to look for the give me a second, guys. Yes. Yes. Now, why is PIL on the increasing trend? Why is it that we see so many PILs? Because the liberal interpretation of locus standi, where any person can apply to the court on behalf of those who are economically or physically unable to come before it. This liberal interpretation has been taken up by courts, and this encourages people to file more and more PILs. It's a very strong and progressive social legislation of India with a wide ambit that has been given to the right to life under Article 21 of the Constitution of India. Now, the format that I just shared with you, if you see, it came in most of the newspapers. Supreme Court asks NGO to move government. Now, in this particular PIL, what had happened is that the court said that you're expecting us to do something. So expecting the court to do something to stop unelected male relatives from exercising real political power behind elected women in the panchayat system was an unrealistic expectation. So court said, hum kya kare? Why is it that you're coming to us? You write a representation to the Union of India, the Ministry of Panchayati Raj, and they will take appropriate action. And We wrote a representation to them and they did take cognizance of the issue, and a committee has been now set up to identify the problem that is there at the grassroots level and how to address that problem effectively. So the court had gone on to say that the matter was taken up by the bench of Justices Honorable Sanjay Kishan Kaul and Sudhanshu Dhulia, and they had asked us to file a representation, and the court had said that this is a mockery of democracy, how the female members, the elected members, instead of them working, it is their the husbands or the devars or the sons who are actually making the decision. There are other also quite a funny incident happened recently. We have filed another PIL that talks about how things are happening, how there are no libraries at the grassroots level. So when the Union of India said that, my lords, we are actually working on e-libraries now, one of the judges mistakenly had referred to Kindle as Tinder, and it was all over in the bar and bench in India today, where they had titled the article saying Supreme Court swipes right on physical copies, confuses Kindle with Tinder. So quite funny, instances also happening in court. So it's not all boring and just kind of theory based, as most of us would like to believe. It is quite interesting and sometimes quite funny also. Now, how do we now coming to an election petition? Now, most of you still studying in college, I presume, law college. Election petition comes very, very rarely for an advocate to file. What is it now? We have to look at it. What is it that it actually talks about now? Now, an election petition is a procedure for inquiring into the validity of the election results of either the parliamentary or the local government elections. In other words, it is a means under law to challenge the election of a candidate in a parliamentary assembly or local election. So elections have already happened and the result is declared, and the party that has not won would say that, something untoward has happened. There was cheating, there was force, there was fraud, or some basic necessities were not taken into consideration when the winning candidate had filed for his nomination. So on technical issues, they would want the election to be cancelled or they want it to happen again. So for that reason, we need an election petition now. Where is it that you file an election petition? You file it in the High Court that has the original jurisdiction to decide on an election petition and of the particular state in which the election was conducted. Now, who can file it? An election petition can be filed by any candidate or an elector relating to the election personally to the authorized officer of the High Court. What is the limitation period? Now, there is a set particular number of days within which it has to be filed. So any election petition calling in question an election shall be filed within the time period of 45 days from the date of declaration of the results. So the Representation of the People Act of 1951, it suggests that the High Court should try to conclude the trial within 6 months, but in actuality, in practicality, it takes years sometimes. So it's not like it will mandatorily be concluded within 6 months. Now, what are the laws governing election petition now? Section 100 of the Representation of the People Act enumerates the grounds for filing an election petition. Section 123 of the Act has a list of what amounts to corrupt practice, including bribery, use of force, coercion, any appeal to vote or refrain from voting on the grounds of religion, race, community, and language. Now, certain previous cases, if you look into, where election has actually been declared void was way back in 1975. At that time, the Allahabad High Court verdict had set aside the election of Indira Gandhi from Rae-Bareli constituency now 4 years earlier on the grounds of corrupt practice. How do we draft an election petition now? We'll have to switch again. Please be patient. Give me a moment. I would again like to share. All right. All right. So if you look at this one, this states, it starts with in the Honorable High Court of so and so at so and so, maybe it is Delhi. You can, whichever High Court. So wherever the election has actually taken place, followed by election petition number so and so of 2020, for example, if this is the year that we're talking about. Then petitioner versus respondents, you write the name of the matter. Then you write the relevant act and the section under which you are filing the election petition. So you say election petition under section 80, 81, read with section 100 of the Representation of People Act 1951 against the election of the respondent from, you name the assembly constituency in dash, praying that the election of the respondent be declared to be void and set aside, with further prayer to declare the petitioner as an elected candidate. So the petitioner wants that, bhai, मैं right candidate हूँ, मुझे जीतना चाहिए था, ये जो बंदा select हुआ है, elect हुआ है, इसके election में problem है, क्योंकि why should it be declared to be void and hence set aside? Maybe certain bribery was used, indulged in, maybe some force or fraud was there, whatever. So you write the name of the place and the petitioner through the advocate. This will be having the signature of the advocate. Now, this is where your petition actually starts. Respectfully showeth. Now, this is where the facts would come in. If you remember that after issuance of the notification by the governor of so and so calling upon the assembly constituencies in the state of, for example, Gujarat, to elect the members for the dash legislative assembly, the Election Commission of India, with a notification issued under Section 30 of the Representation of People Act. Now, because we will be referring to the Representation of People Act so many times, we write here and after refer to as the Act in short. Announce the program for holding of the elections to the dash assembly as follows now. Filing of the nomination paper, you mentioned the date here. Scrutiny of nomination paper, kab hui thi scrutiny? Withdrawal of nomination paper, allotment of symbols, date of polling, counting of votes. Now, all the dates have to be mentioned here. Now, the petitioner filed his nomination paper on, again, the date being set up by the dash party, and the respondent filed a nomination paper sponsored by so-and-so party from dash constituency. After scrutiny and withdrawal of the nomination papers, as many as dash candidates remained in the field and the polling took place on dash. So how many candidates were declared to be eligible? You write the name, the number of eligible candidates here, and you write the date of the polling here. Now, after the counting of votes, the result of election was declared by the returning officer on. Now, this is the date on which the election results are declared. So starting from this date, you have a period of 45 days within which this election petition needs to be filed. And the candidates were shown to have secured the votes. Now, top 4 candidates, for example, the name, party, and the number of votes. And the respondent, so-and-so, now this is the candidate who actually won, right? Was declared to have been duly elected by the returning officer on this. This is the date of actual declaration. Now, para 3, that the returned candidate, that is the respondent, you write the name of the respondent during the impugned election, that is this, mention the election. The respondent committed, now this is para 4 is where you tell the court, what is it that, why is it that you are challenging this election? The respondent committed the correct practices as envisaged under section 123(7) of the Act as you enumerate what were the corrupt practices. This has enhanced winning chances of the respondent. So you say कि उसने ये सब करा था, इसलिए उसके chances गलत तरीके से बढ़े. Para 5, that the respondent committed the corrupt practices of bribery as envisaged under section 123(1)(a) and (b) of the Act, as then you mentioned, kya bribery kari thi. This has enhanced the winning chances of the respondent. Any other grounds, any other facts that you need to allege, you go here, so on and so forth. And then you come to the grounds. Now, the grounds are the basis, the premise on which you come to the court. Now, the petitioner is invoking the extraordinary jurisdiction of this honorable court and seeking indulgence on the following grounds amongst other, each one of which is without prejudice to and independent of the other. So you go on and you enumerate the grounds as A, B, C, D. That such an act of omission and commission on the part of respondent, whereby they have whatever it is that they have done, is illegal, arbitrary, mala fide, discriminatory against the well-established principles of natural justice, as well as violative of the mandatory provisions of the Constitution of India. Then you go on, you make more grounds. On what grounds do you allege that this election should be set aside or quashed? That the impugned act of the respondent is against the well-settled principle of law laid down by the Honorable Supreme Court and this Honorable Court in a catena of cases. This is where you cite the case law. That the petitioner has deposited rupees so and so as security in this Honorable Court with a receipt number, that the petitioner is submitting 2 extra copies of election petition duly attested. That the election under challenge pertains to, you write the name of the constituency which falls within the jurisdiction of this Honorable Court. So this is to show that the court has proper jurisdiction, territorial jurisdiction. That the petitioner has no other speedy, efficacious remedy available except to approach this Honorable Court by way of present petition. That the petitioner has not filed any other petition. See, this is how important this is. If any of these are not there, please understand in your petition, any of these points, then your petition would not be listed because it will be under defect. These are extremely unavoidable, so to say, paragraphs that you need to include in your election petition. That the petitioner has not filed any other petition on the same or similar grounds, either before this Honorable Court or before the Supreme Court of India. Now we come to the prayer. Most important of all, why is it that we come before this court? That the petitioner therefore prays that for the reasons submitted in the election petition, prayer number 1 is the election of the returned candidate. That is the respondent. Now this is returned candidate means the winning candidate. From dash assembly constituency of dash legislative assembly be declared void, set aside. Respondent be declared to be disqualified from contesting elections. Cost of the petition. Any other relief. See, this particular paragraph has always, it needs to be there. This is for any event where you forget to ask for certain things and the court says, well, you haven't asked us, so how can we give? In which case you cite this particular para and you tell the court that, well, my lords, we have included this para and you can grant us relief under this particular para because this leaves the space open, allows such other relief or pass such other orders as deemed fit and proper in the facts and circumstances of the case in favor of the petitioner, and let justice be done. And for this act of kindness, the humble petitioner, as in duty bound, shall ever pray. You write the place, you write the date, and the petitioner through advocate. This is where you sign the verification affidavit. This needs to be there. And these are certain annexures that depend on the rules of every high court. Now, then we again come back to the main PPT. Move ahead from here. Now, why is it that election petition is important? Now, election commission's role, even though an election commission has been established to make sure that the elections are done in a fair manner, fair and proper manner. But what happens is that their role ends with the declaration of results. Now, this is where the problem starts. The results have been declared and one party feels, well, nahi, ye to galat ho gaya. Galat tarike se result declare hua. So after that, an election petition is the only legal remedy, so to say, that is available to a voter or a candidate who believes that there has been some hanky-panky, some malpractice in an election process. Now, Malpractice is the counting process, which includes improper reception, refusal or rejection of any vote, or the reception of any vote which is void. Now, non-compliance with the provisions of the Constitution or the Representation of People Act or any rules or orders made under the Act. Now, all these things would result in the filing of the election petition. You must be knowing that recently there was a video of one of the officers that was counting the votes and how things were being done. So that has called for the filing of an election petition, obviously. Coming now to the drafting of a caste scrutiny writ petition. What is it? What is it a caste? What happens is that suppose you were relying upon a caste certificate in order to get maybe admission somewhere or a job or whatever. Now, what happens when the caste scrutiny committee cancels that caste certificate or says, well, that go away, this is not proper, this cannot be taken on record. Now, the caste verification committee, or sometimes also called as the caste scrutiny committee, have been constituted by different state governments for the verification and cancellation of caste certificates. If any complaint is made against the caste certificate of any person of any particular category, be it SC, ST, OBC, EWS, whatever, with the allegation that he has obtained forged caste certificate, the same shall be verified by the caste scrutiny committee in accordance with the procedure prescribed by the rules or the government orders that are passed from time to time. Now, sometimes hasty decisions without verifying entire documents are taken by the caste scrutiny committee, which results in the wrong cancellation of the caste certificate and causes a lot of, injustice to the person concerned. So in order to combat that, we need to file a writ before the court. How is it that the caste certificate is issued? Now, the caste certificate is issued by the revenue authorities. Normally, what happens is that the caste certificate is issued by the Tehsildar or the SDM. They are the appropriate authority, competent authority to do the same. So what happens is in certain states now, there are special officers who are appointed or power is delegated to a particular officer, empowering him, the duty in order to issue the caste certificate. Now, whether the issuing authority can cancel the caste certificate, now it is settled now by a catena of decisions that caste certificate cannot be cancelled by the authority who has issued the caste certificate. And the Honorable Supreme Court in a landmark judgment has streamlined the procedure for cancellation of caste certificate, because you see this is a big issue and it will affect the future life of the person concerned. What is it that the caste certificate tells you? It tells you that a person is of a particular caste. It is a proof that you belong to the caste. It is a proof that if you're alleging that you are a person from, for example, a scheduled caste, reserved category, scheduled tribe, or one of the backward classes, then how do you take benefit of that? You have to show your caste certificate. That is the proof that you belong to that particular caste. Now, it is required normally by the members of scheduled caste, scheduled tribes, and other backward classes for claiming the benefit of reservation and admission in academic institutions and in seeking employment. Now, caste is obtained by birth. So caste certificate, it cannot change the caste of the person. It can only certify that the person bearing the caste certificate is of the caste which is mentioned in his caste certificate. So it's sort of a ratification that yes, whatever he says is correct, he's actually from this caste. Now, what happens if it is wrongly cancelled? In every state, at different levels of hierarchy, committees or forums have been created by the different government orders. At the lowest level, starting from the district level, caste scrutiny committee, this committee is responsible for verification of the caste certificate and cancellation of the wrongly issued caste certificate, which is headed by the DM. Then at the intermediate level, there is also an appellate forum. So now you have a particular order that was passed by the DM. You are aggrieved by that order. Where do you appeal? You go to the intermediate level, which is an appellate forum or a committee which is headed by the commissioner of the division. Now, any person who's aggrieved with the decision of the district level caste scrutiny committee, he will file an appeal before the first appellate forum, which is, like I said, the intermediate level, within a period of 30 days from the date of knowledge of order passed by the district level caste scrutiny committee. Now, right at the top now, starting at the district level, we then have the appellate level, which is at the intermediate level. Then if you go right at the top of the hierarchy, we have the state level caste scrutiny committee, which has been constituted. So any person who's aggrieved with the decision of the first appellate forum may further file an appeal at the state level caste scrutiny committee. And the state level caste scrutiny committee is headed by the principal secretary, social welfare. Now, is any sort of notice necessary to the person whose caste certificate is under cloud? Cloud means under some sort of a doubt. Now, any administrative action that would have civil consequences must be taken in accordance with the principles of natural justice. So you can't simply just, call that person and say, "Bhai, tumhara caste certificate humne cancel kar diya." You have to give him an appropriate opportunity in order to explain himself. The person whose caste certificate is under verification must be provided an opportunity of hearing in support of his caste claim. Let him tell how he can prove that he is of that caste. Person must be afforded an opportunity to submit documentary and oral evidence in support of his caste claim. Entire documentary and oral evidence must be properly considered, appreciated by the caste scrutiny committee. So you cannot just hurriedly pass a verdict saying कि भाई जाओ यहाँ से, तुम्हारा caste certificate गलत है. You give him an opportunity, let him explain, let him place on record certain evidence, whether it is oral, whether it is documentary, whatever it is that he has, and then you take action on that particular evidence, and then you pass a reasoned order. Now, suppose you have taken note of every evidence that he had to give you, took note of the documentary evidence, certain documents he showed you. Then he also gave certain oral evidences. Now, still you went ahead and you cancelled his certificate. Now, what is the remedy available to that person who's aggrieved by the decision of the top level, which is the state level caste scrutiny committee? So any person who's aggrieved by the decision of the state level caste scrutiny committee can file a writ petition before Honorable High Court under Article 226 of the Constitution of India. 226, 227. Now, the writ petition is normally filed before Honorable High Court on the ground that the decision taken by the caste scrutiny committee is perverse. It is in violation of principles of natural justice, in violation of the procedure that has been prescribed under the rules, and consideration of the irrelevant material and ignorance of the relevant material, so on and so forth. You take the grounds. How is it that we draft a writ petition challenging order of caste scrutiny committee? It is exactly on the same grounds as I explained right at the beginning, and thereafter, as far as the writ concerning election petition was concerned, you start with the facts of the case, then you go ahead, you write down the grounds. Then you mention those 3-4 paragraphs that you say that, your matter is well within limitation. There is no inordinate delay. There is no other petition that is filed before any other court on similar topic, similar, cause of action. And then you ask for a prayer. You also annex the annexures that you're relying upon. So I'll share with you one of the orders that have been passed in a caste scrutiny committee. Let's see. This is a caste scrutiny judgment. It's taking some time. Yes, you see, this is a judgment of 2022 in the High Court of Judicature at Bombay, Nagpur bench, writ petition number 6515 of 2022, Kumari Parvi Ashish Chakravarti versus, if you see, this is the particular state of Maharashtra through its principal secretary. We've also implemented the district caste scrutiny committee. And then the court has gone on to first, they are discussing the facts. You see, in any judgment, when it starts, they will tell you who the petitioner is, what are the facts, briefly stated facts of petition, they are summarized. So this is a case where the petitioner had passed his 12th standard examination in the current session, and she had claimed to be belonging to the Mahar community. And the caste scrutiny committee had gone ahead and said that no, she's not Mahar. She is basically a Christian, because when the vigilance officer had gone to check her house, he had seen the picture of Jesus Christ. So they're discussing the case law, you see. It's a detailed reasoned order. Let's come to para 21, where it's a relevant paragraph, so you can understand. The court, in a latest judgment in the case of Preeti, which is on identical facts, held that Divisional Caste Scrutiny Committee should not have rejected the claim of the petitioner as a candidate or invalidated the caste claim. In the said case, it is contended that the petitioner failed to produce caste claim documents. So the court gives its reason that this is not right. What the Caste Scrutiny Committee has done, we make it clear that if, in spite of the aforesaid directions, that the members of the committee continue to deny validity certificates to the candidates, in spite of there being pre-constitutional documents with them, and when there is no material available to contradict their claim, we will be left with no alternative than to take serious view of the matter. So they've passed an order. They have said that the petition succeeds. That means the petitioner has won the case. They have quashed and set aside the order that said that she's not, the petitioner is not of the Mahar community, but she's a Christian. So they've set it aside. Respondent number 2, which is the District Caste Scrutiny Committee, is directed to issue caste validity certificate to the petitioner as belonging to the Mahar, which is a scheduled caste, as notified at serial number 37 in the Constitution, within a period of 2 weeks from the date of receipt, and so on and so forth. So I think this is where we have covered all the relevant topics. Let me check it. Yes, we are pretty much at the end.
Thank you. Yes, ma'am. Thank you so much. Thank you so much for covering each and every subtopic in a very much detailed manner. And thank you so much for covering it in a practical sense, in addition to the basic sense, because our students are there and even the advocates are there. So it will be very helpful for them. From the basic to advanced, the way you have carried the topic was indeed a commendable way. Thank you so much, ma'am, for accepting our invitation and addressing the virtual gathering in such a commendable way. I, on behalf of Legal Expatriate, express deep sense of gratitude for spending your most precious evening with us. Thank you so much, ma'am. Thank you so much.
Pleasure for me as
to have you. Yes, ma'am. Hope to have you in future sessions as well. Thank you so much. We will always need your support for the team.
Thank you so much. Have a happy weekend, all of you.
You too, ma'am. Thank you so much.
Thank you.
The
Bye-bye.
participants are actually giving the feedbacks in the chat box itself. The session, they liked it. The session was really very wonderful.
Oh, wonderful. Thank you so much. Appreciation from you is always needed and always appreciated. It is nice to know that whatever I say makes sense.
They like the session, ma'am. The chat box is full of feedbacks.
Thank you so much. Thank you, everyone. Have a good evening, all of you. Bye-bye.
Thank you so much, ma'am. Thank you.
All right. Yeah.